The minority would do whatever is lawfully and properly within its power through Parliament and through public advocacy to see that justice is done and that the defects which have robbed the judgment of its legitimacy are corrected. 4 serious defects run through this case, and each deserves nation's full attention. First, the denial of a council of choice. We understand that judgment was delivered despite the absence of Chairman Wontumi's lead counsel, whose office had notified the court of a prior professional engagement abroad. Second, the refusal to refer serious constitutional questions to the Supreme Court. The trial judge decided for herself that Section 99 2B of the Minerals and Mining Act was, in her own words, clear and unambiguous. Third, and perhaps most vulnerable of all on the law, is how the court pierced Akonta Mining Limited's corporate veil to convict Chairman Wontumi personally. The judgment convicted Wontumi and the company separately on separate counts, using reasoning that treats them as one and the same. A court cannot dissolve a company to convict the man. Fourth, selective justice. In July of last year, the Attorney General directed an investigation into the NDC's own national organizer, Mr. Joseph Yami, and its vice chairman, Mr. Yakubu Abanga, over allegations of illegal mining. Months later, there is no comparable update on charges or trial dates. The government member of Parliament has publicly acknowledged overseeing a mining site taken over from its lawful owners with no prosecution to date. And an NDC member of Parliament charged over an anti-Galamsey clash was granted bail within days. This pattern, taken together, sustains a reasonable perception that the machinery of the state moves fastest and land hardest when it is pointed at the political opposition. A government serious about ending selective justice must prosecute its own with the same vigor it has shown here. We therefore call on the Attorney General to publish the state's enforcement record on illegal mining across the political spectrum. We call on the Court of Appeal to scrutinize the denial of counsel, the refusal to refer, and the veil piercing with equal and unflinching rigor. We call on the judiciary to reaffirm the threshold for constitutional referral, with express regard to the Supreme Court's own decision in the Zanato case. And we call on all Ghanaians of every party to insist that the standard which cleared Mr. Chikese's name in 2016 be demanded with equal conviction today. Let us be clear about what this statement is not. It is not an attack on the judiciary as an institution. It is a call for consistency, for constitutional fidelity, for a justice system that inspires confidence across the political divide and not merely within it. History would not remember this moment for the length of sentence. It will remember whether Ghana, when tested, chose to defend the Constitution for everyone, or only for the power of the day. We choose everyone. We choose the Constitution, and we will be judged rightly by whether we meant it. Chairman Wontumi is a political prisoner.